Thank you. Martha Brooke Martin is going to be talking about wills and advance directives.
Hello, how are you all? Y'all know me here as Martha Brooke Martin. You probably see a Martha Brooke Perry up there. I started practicing law under Perry as my maiden name, and so depending on what checkbook I'm working out of, I have to figure out who I am at that particular moment. So anyway, but thank you all for coming. And I appreciate the chance to come talk to you guys. Can you all hear me okay? Too loud, too soft? Okay. All right, so we're here tonight to talk about wills and advance directives. Most all of you heard about wills. There's that. She can do that while you're alive too, though. Yeah. So to control some assets, maybe. What else?
If you don't do it, the state will.
I hear that a lot. If you don't do it the state, what do you mean by that?
Well, the state sets up a format that they, for anyone that doesn't have.
They direct how it's going to go.
And
Yes.
handle according to state's law.
That's right. That's right. We're going to talk about that in a few minutes. But yes, a lot of the questions I have for somebody come into my office is, well, if I don't have a will, then the state's going to get everything. And that's not the case. But you're right. The state does have a format that says, here's how it's going to go if you didn't make the arrangement yourself. What else?
Prevent fighting among siblings.
Yes. Yes. And yes. Mm-hmm. That's right. That's right. Any other reasons? All right. I'm going to do the next one. Okay, so we see up here to help your family or caretakers take care of you when you're unable. A lot of times that applies to a power of attorney because as I mentioned, those are effective while you're alive. So if you're not able to make your own decisions or physically not able to get out and conduct business or things like that, that power of attorney comes in very helpful for someone trying to help you. To make your wishes known about your preference for life support and organ donation. Some people, they don't really care. Some people, it's I have drawn some very specific living wills as far as what they want in those end days. To distribute your assets as you want them to be distributed, that's the one you touched on, Marshall. To help cut down on the cost of probate, that's a lot of times a big concern that a client has when they come in, and so we'll talk about that a little bit. Minor children, and not just if you're a parent with minor children, but even if you're a grandparent and you want to leave something to minor children, it's important to have these documents in place because if you don't, and they get a bequest from you and your estate, the clerk of the court typically will hold that money until they're 18 and then they're turned loose with it at the age of 18. So if you have minors, it's important to get these documents in place because you can control when they get that money and who takes care of it until they can get the money. And then to make life easier for people who are helping you while you're alive and who are settling things out after you pass away. All right. So what does a will do? We've kind of touched about this a little bit. A will basically lays out who you want to get what and who you want to be in charge of handling your items out, marshaling your assets, paying any debts, and then handing things off. You can specify who you want to receive your assets, family, friends, church, any other charitable organizations. You can make those specifications. In your handwriting or typed. I'm sorry, I should be more specific. So it's got to be a standard will like what we do in our office. It has to be signed by the testator and 2 witnesses. Now, I heard notary. A lot of people think that it has to be notarized. That notary is actually signing an affidavit, notarizing an affidavit of the 2 witnesses. The 2 witnesses are saying, we saw this person sign. We were sitting in front of each other and we saw each other sign. The person was competent and over the age of 18. And that's what is called an affidavit, self-proving affidavit. If you don't have that page attached to your will, then when you probate the will, you have to bring the witnesses in front of the judge. But if you've got that document attached to it, that acts as them offering testimony in court. And so they don't have to come to court to say, yes, I saw all this happen. So 2 witnesses. So you don't have to have the notary, but it makes it a lot easier on those witnesses and your attorney by having that self-proving affidavit. And I just covered that part. So now holographic will, we talked about writing. So let's say you realize you're going to die tomorrow. You may be the only person in the world that realizes that, but you're going to die tomorrow and you don't have time to get to your attorney's office or gather 2 witnesses. What can you do? You can write your will in Tennessee. It has to be all in your handwriting. Somebody can't write it for you and you sign it. It has to be all in your handwriting. It has to be signed and should be dated so that people can readily tell if it's truly your last will and testament. Now, that is, as a lawyer, I'm going to tell you that's a poor option. That is a stopgap. You don't really want to have to go down that path, but some people just, that's a scotch that they have to do. So it's a headache to probate those, but sometimes you just have to. All right, so what do you need for your meeting with your attorney? So I'm going to hand out some forms. I made 15 copies, so if I've got family groups that can share, I would appreciate that. And if you don't get one tonight, let me know and I can email or bring some more to church. But this is just something that I came up with. These are the questions we typically ask when people come into our law office and I'm sitting down with my yellow legal pad. I'm going to need to know, obviously, names, how people spell their names. I mean, I've learned over the years there's 3 or 4 ways to spell Ann, so very specific, or maybe you just prefer to use a middle initial when you do legal documents. So that kind of information is important. Where you live is important because when we draft our wills, we typically note your county of residency. Now, if you sign something, you're a resident of Davidson County and you move to Hamilton County, you don't have to redo your will for that. It's just, something we like to have on the front end. Also, this form you'll see, and I'm probably blowing through some of these, Michael, without nodding my head, you'll see where it'll ask you who you want to be your executor. And an executor is somebody that is going to be the person in charge of walking your will through probate court. They're going to be the ones that go and get what we call letters testamentary. That's their ticket to act in your shoes on your behalf once you're deceased. They are the ones who are in charge of getting all your assets together, figuring out if you owe money to anybody and getting that paid. And then after that's taken care of, handing the balance of those assets out according to your will. So that's what you would need to know is who your executor is going to be. You also need to know, what do you own? You know, that's important because sometimes I've had people come in, oh, I forgot to include this. Because that was our trail to where everything she had. And then an idea of specific bequests. So a specific great-grandfather's pocket watch to go to the firstborn grandson, or I want this piece of land to go to this child and this piece of land to go to that child. So if there's anything like that that's important to you that you want a particular person to have, that needs to be spelled out. You do not want to say, well, I want this person to have this, but they can sort that out after I'm gone. All right, a couple of reasons. People may not play so nicely after you're gone. I see that. I had an estate that was open for 6 years. It was a blended family, and those kids got in there and argued down to the last garden gnome and garden hose over who was getting what. Paid me to sit there for 4 days as they divided up all those assets. And I'm thinking, do you know how many garden hoses you could buy for how much you're paying me to stand here and watch you do this? So specific things, get it in there. Another reason that it might not happen like you want to is, I see this a lot of times, I'll see mama leaves her life insurance to the daughter, and with the understanding that daughter will share that with the other siblings. Daughter may very well intend to do that, but daughter may have creditors. She might not have paid her IRS taxes. And guess who gets their hand in there first? Or daughter and mom are going shopping together and get killed in a car wreck together. And guess what? Daughter's not there to cash in the policy, but her no-good son-in-law is and gets the money instead. So there's reasons you want to be very detailed with what your wishes are. And then the last thing is everything else you haven't specifically said, you need to say who you want everything else to go to, your residuary estate. So on that form, you'll see places where you can kind of start, the idea is to make you start thinking about what all those things are. So, what about a trust? So we have a couple of different trusts. You probably all have heard about these. They're in vogue, and they're good in different situations and not so handy in others. In your will, they're called a testamentary trust. A lot of times you'll see those, especially with minor children, you'll say, trust to manage these assets on behalf of the kids. Trustee can use any amount of that money to pay for health and education and general welfare of the children, and then the kids don't get it till a certain age. Like for Silas, for my child, we have it staggered out where he only gets certain percentages once he hits certain milestones, and he has to get some age under him. Because our philosophy was, if you take everything that we have, house, insurance, retirement, and all that, and liquidate it down into $1 figure, that is not something that needs to be in the hands of an 18-year-old or a 21-year-old or, quite frankly, a 25 or 27-year-old. Not that it's a great amount of money, but I don't really want my hard-earned assets to go buy the latest Rivian truck and whatever other fun iPod that might have come out that year, okay? So, it can be detrimental to some people if they don't have the ability yet to manage their funds. And that's, as you all know, you grow into that. Life happens. Jeffrey and I were gone, and Silas was 25 years old, and he had a good head on his shoulder, and he was ready to buy a house. Trustee could take money and make a down payment on that house for him. So it's not totally out of their hands. So that's what a trustee is. They provide the assets, the person to hold the assets, and then it'll be distributed to the beneficiary according to your instructions. And then we talked about why it was important for minor children. You can also, it's helpful for estate planning, depending upon the value of your estate. You may need to set up certain types of trust to get as much advantage of those exemption amounts that scooted out from underneath the grab of the government on taxes, as well as if you have blended family. So let's talk about taxes. Is anybody in here? Well, there's the answer. There is no inheritance tax in Tennessee. As of 2016, that was done away with. But we do have one on the federal level. In 2022, it's 12.06. That will go up in 2023, but in 2024, currently it's expected to sunset and will drop back down. So we don't really know where we're going to wind up in 2024. So, and again, if you have a taxable estate, then you do need to get a little bit more specialized planning. Planning with minor beneficiaries. We probably have covered a lot of this. So, Michael, if you'll go ahead. All right, so if you're a parent, you need to consider, who do you want to raise your kids? This is the one that a lot of my parents that come in to visit with me have a hard time with, because one wants one side of the family and one wants the other. Or you could be like Jeffrey and I, and we particularly say, this is who we don't want to have our child. But if you're a parent of a minor child, then you'll want to put that in there. You can't will your children in Tennessee, but you can establish what your preference is. And that's something that a judge, because the judge would be actually making a custody determination once you're gone, a judge is going to take into account what your wishes are, because they know that when you sign that will, you truly have the best interest of your children at heart. Somebody asking for custody of your child might be wanting custody because they think a dollar amount is tied to that child. So that's where you establish what your preference is. And it's got pretty heavy weight. Who do you want to manage the kids' money? We've talked about a trustee. Doesn't have to be the same person that takes care of your children in a guardian aspect. It can be two different people, and sometimes it's more beneficial to have them as two different people. What age do you want your kids to receive the money? We talked a little bit about that. And then we've talked about how trustees can have discretion to spend funds that may be needed for your children. And education, I'm going to highlight health, education, general support needs. That's pretty broad. Education can be not just tuition. It can be ballet classes. It can be going to Spain one summer in college to study Spanish. That's a pretty broad thing. Same thing with health and general needs. All right, so what happens to your estate after you die. Anybody here been through a probate process? Good, bad, scale of 1 to 10, how would you rate it as far as good experience? It was good? Good. It is. And depending upon if your ducks are in a row or not, it will make it easier for the person who's being the executor. I'm sorry, could you jump back one more? Was there anything else on? Okay, let me just jump in here. So what happens in a probate in Tennessee? So if you have a last will and testament, that gets presented to the probate court to be recognized. Okay, this is the person's last wishes. And so at that point, the judge would say, here's the will. Here, Mr. Executor or Mrs. Executor, are your letters testamentary. Then your executor at that point is on go to go getting all the assets, as I talked about. If there's any known creditors, they've got to send them a letter that says, hey, file a claim against the estate. If not, you just kind of have to sit there and keep your estate open for a minimum of 4 months in the state of Tennessee. Because in Tennessee, you have 1 year from the date of death from when you die for a creditor to file a claim. But if they're known and you've sent them a letter and says, hey, you need to file a claim, or you've run the ad in the newspaper, y'all sometimes see those notice to creditors, run that in the newspaper, that cuts that period down to 4 months. So assuming we've got our creditors taken care of, we got to get a 10-care release. Everybody in the state of Tennessee, doesn't matter if your name is Bill Gates or Warren Buffett, you have to prove that 10-care did not pay for nursing home benefits for you. So you got to get a 10-care release. You get those assets handed out. You get a receipt from everybody that got an asset. Follow that with the court, and then you can close it out. So I know that sounds like a lot of steps, but it's actually not that onerous. Generally, of course, I'm in Cheatham County. It's a little bit cheaper there than here in Davidson, but generally in Cheatham County, you can expect to spend about 4 to 6 months getting it done, and you get it done for between $1,500 and $2,000. So.
What receipt were you talking about?
I'm sorry?
If you receive an asset, you have to give them a receipt?
Yeah, so let's say if I left you my car and my will, then my executor has to prove that he gave you my car. So you would sign a receipt that says, yes, I got what I was supposed to get. And then he files that with the court, with the probate court. Because if you've got a will where you're just basically leaving everything to this person, it was 3.
So I don't need a receipt?
Is the estate still open?
It's just about closed.
Okay, before you close it, you'll have to get receipts to file. You have an attorney? You're not, okay, all right. The attorney that's working with that, he'll probably tell your brother, get receipts. So you'll probably be seeing one of those soon. So, okay.
I have a question.
Yes.
What is probate?
I don't know the actual definition, the actual word, but it's the process where you are recognizing the will and taking care of any last business for that person, settling out debts and making sure property gets handed out like it's supposed to. All right, and then we've kind of already talked about the steps that we have. And then there's our receipt. Okay, question. I'm gonna be very impressed if somebody gets this. Jarndyce versus Jarndyce. Does anybody get that reference? Has anybody ever read Bleak House by Charles Dickens? Okay, I guess I'm a nerd. I read it when I was in high school. You know, Charles Dickens always has an underlying story, an underlying thing that's going on throughout the whole book that all the other sub-stories circle around. And Jarndyce versus Jarndyce, Bleak House. Jarndyce versus Jarndyce was a probate of an estate that took decades to get out. At the end of the book, spoiler alert on a Charles Dickens book, at the end of the book, the estate closes out, everybody rejoices, and guess what? The lawyers got all the money. Because it took so long. So if you have your ducks in a row and you've got your will in place and everything like you're supposed to, you can avoid having a Jarndyce versus Jarndyce situation where the lawyers get it all. Okay?
So let me ask a question.
Yes.
If there is like a mortgage on a home that's part of the estate, you don't just automatically pay that off, you wait for them to...
Well, real property, land, houses, that's treated a little bit differently than other assets. So in Tennessee, your home or your farm or any piece of land like that is vested automatically when you draw your last breath on your heirs. It transfers to them, and it's only subject to control of the probate estate if it has to be pulled back in to be sold to pay any other debts you may owe. So whoever inherits your home or your land is inheriting it with the mortgage on it. So they have the choice of refinancing it or paying it off and selling it. They're taking it subject to that lien. Yes.
Quick question. If you have a loved one who dies and has left assets to you, how is it, like, if there are taxes due, federal income taxes due, how is that handled?
So typically, if you've got, I'm sorry, and I keep forgetting to ask the question out loud, Michael, you'd asked me to do that. The question was, if you have a loved one that has left assets to you and there's inheritance taxes or even maybe income taxes or things like that that are left, how is that handled? Yeah, they would have to be paid. So any asset that is in control of the probate estate, then that would be subject to use for payment of any debts owed. Okay.
So you need to perhaps liquidate assets that you receive.
Correct.
Turn into cash and send Uncle Sam a big check.
Correct. A lot of times people will have, their bank accounts are going to have pay on death beneficiaries on them or life insurance. That money actually goes outside of the probate estate. It goes straight to those beneficiaries, not subject to claim by creditors. But if you got land that's still in your estate, your cash is gone to pay for it. The land is gone. You can't convert. I'm sorry, let me back up for a second. The cash in those bank accounts is gone because it's transferred on death, but you've got the land. And so it would have to be sold to pay for any taxes. Taxes and estate administration expenses and attorney's fees are given priority on a probate estate. Taxes, administrative expenses, and attorney's fees. Those are super priority on payment. If you don't have enough cash, and even if you sell your land and there's still not enough cash to pay all your debts, then the probate court will start ranking people. So the government's going to get theirs, the court's going to get theirs, and the lawyers are going to get theirs, and then we'll sort out and see who gets what's left.
So the estate is like a bankruptcy?
It's called an insolvent estate. Yeah, and then you divide it out proportionally, whatever's left over at that point. So.
Is the basis of taxes, the basis still go rise with the death of someone?
Robin, that's a great question. He asked if the basis, and you're talking about a cost basis, still rise on the death of someone. That is a great question. I'm gonna jump off slides for just a second because I get this question a whole lot. What if I want to transfer my property to my child while I'm still alive? A lot of times, I don't want the nursing home to get it. I want to protect it from claims by a nursing home. And that's all well and good. If you have a house and you put your child's name on it, you keep a life estate, and you pass away, if you survive that transfer by 5 years, then if the state of Tennessee has paid any benefit for you to stay in a nursing home, and now it extends to home health care, if they pay any benefit to you for that, then you survive that by 5 years, they can't pull that back in. If you go into the nursing home, state pays for your care, and you die before 5 years, they can pull that transfer back in and force the property to be sold to be reimbursed. Okay, so that's a good thing. But to Robin's point, your cost basis on that, because it was a lifetime transfer, would be what the parent bought it for. So let's say I bought my house for $100,000. I transferred it to Silas because I didn't want the nursing home or the state to get money because of paid nursing home benefits. And I pass away and I've survived 5 years. So Silas has that piece of property, doesn't have to worry about TennCare. But Silas's cost basis in that is the $100,000 that I paid for it. And where that becomes important, if Silas then turns around and sells that piece of property, and it's been 20 years or 30 years since I bought it, Silas is going to have a nice capital gain on that because he's going to take the difference. Let's say he sold it for $300,000. He's got a $200,000 gain between what I paid for it and what he got that he's going to have to pay capital gains taxes. Okay, so we've dodged our nursing home bill, but got bit on capital gains. There's a possibility that he could do a 1031 on that, a 1031 exchange. Most people don't because you have to identify a certain piece of property within a certain number of days and get it closed on and all that, okay? But let me jump in here real quick, then I'll jump back to your question. But let's say that I decided to take my chances. Maybe I have a really good long-term care insurance policy or something like that. And I say, Silas, you can't. So if I die, Silas inherits it on my death. Its cost basis becomes the value of my death. So it becomes $300,000. And if he's so generally, you can take your property tax card. I mean, that's a government assessment of the value of your house. Generally, that can be used. Now, if you're getting into a larger estate or you think you may be having a tango with the IRS, then you're going to want to get an appraiser. And they can look back historically, what transfers of sales were back at, a certain period of time, etc. So there are ways to get to that professional persons you can hire if you need to. It's not uncommon for estates to get appraisers. And you mentioned somebody buying somebody out. If you have 3 children, 1 house, then you may want to say, littlest son has a right of first refusal on a fair market value. You get an appraisal of what the value of that house is, and then everybody knows where you're jumping off from at that point. Correct. All right. Before we jump to power of attorney, I think I skipped a slide. You were there, but I wasn't, Michael. What happens if you don't have a will? We mentioned that previously. The state says who gets what. That's called intestate succession. You don't have a testament, so you are intestate. And basically in Tennessee, your assets would be divided between your spouse and your children. So this can really be a problem for people with minor children that don't have a will, because if there's any asset that doesn't transfer automatically by a pay on death beneficiary or the way you hold title to something, let's say if you've got a husband that has something, a piece of property in just his name, and he doesn't have a will and he dies, then his wife and the minor children will own that piece of property, and you can't sell a piece of property in a minor child's name without court approval for it. So it can be a real headache. So that's why it's critical to get everything like you want it and lined up. All right. So we're getting ready to jump into power of attorney. Is there any great pressing question?
If, for instance, you have your retirement account or a 401k, and you've listed beneficiaries within that plan, that doesn't have anything to do with a will.
That's exactly right. That's going straight to who you have designated. When you have a retirement account, banks, sometimes when you open a checking account, they say, do you want a beneficiary listed? CDs that you get, brokerage accounts, a lot of those will have where you can designate a beneficiary and an alternate. And those pass outside of probate. So a will is only going to control what is running through the probate court. Okay. Right, because that is actually a contractual relationship that you have with the holder of those assets to pass those off according to your wishes after you die. Okay, and let's talk for just a second about 401ks, IRAs, and things like that. This is a little tricky with minor. I'm going to look at this other. This is a little tricky with minor children because you want most all of those assets to be controlled by that trust. Because as I mentioned, you don't really want an 18-year-old running around with a bunch of money. 401ks and IRAs are the exception to that. You don't want to run them through a trust because they get bit at 35 to 39% taxes. Those retirement accounts can only be held by individuals. Can't send them through an estate or a trust. So you're better in those instances, even though we got minors, to have them listed as the beneficiaries because they can enjoy those tax benefits that the 401ks and IRAs are designed for. And they do have some control until they're 18 or 21, depending upon that. And then you just hope and pray that they'll have a good enough head on their shoulders to leave them alone and have a nice start on their own retirement account. Yes?
What's a good person to take as an executor if you're 36?
If you're 36. So you want somebody as an executor that is got some business acumen, that doesn't get overwhelmed easily, has a pretty good head on their shoulders. If you've got a sibling or somebody like that you trust implicitly, those are usually good picks, or good friends. It's preferable in Tennessee, not necessary, but preferable that the person live in the state of Tennessee if your assets and your estate's going to be coming out of here. But if that's not an option, and that's quite often not the case, there are some exceptions that can be made for that. So somebody you trust that you know is going to be able to handle that. So same thing with a trustee. Somebody that is not going to easily be swayed by a child asking for money every time they turn around, but also is, going to know to sit down with a financial advisor and get the best that they can for protecting that money and letting it grow till the kids get of age. Any other questions? All right, so let's talk about power of attorneys then. Two kinds, general and healthcare. How many people in here, I said I wouldn't do it on wheels, but how many people in here have power of attorneys in place? Okay, good. So do you have two kinds? One, yeah. So healthcare and general power of attorney. So the power of attorneys allow you to appoint someone to handle your business affairs. That's covered under the general power of attorney, or somebody to make healthcare decisions. On a healthcare power of attorney, you can verbally override that. So if you have somebody appointed, Georgia, let's say you've appointed me as your healthcare power of attorney, and we're at the hospital, and I'm telling the doctor, you need to work with all this medicine. You're in your right mind. Sure. And there's no firm answer on that. I mean, it's just all of these documents are things that you need to periodically pull out and review. When you've got minor children, you need to have that out every 3-4 years and looking, okay, these people that I've got picked out to take care of my kid's money, do I still want that? Are they still, if it's your parents, are they still at that point in life where they can care for them? So it's something you need to reevaluate as you go along.
Well, Maryland has power of attorney, does power of attorney, but they much first to put, do I have to list my son in case right before I die, Maryland,
Sure. So, yeah, that's very, very frequently a situation that you can have, or dementia comes in and you can't make those changes and your spouse has passed away.
Have that in the power of attorney that our son knows he will then have the medical power.
It needs to be in there if that's what your wish is. So I typically will do it one of two ways. I appoint my spouse and my child both, and either one of them can act without joinder of the other. So whoever's convenient. Incompetent as certified by the physician. We'll put a whole paragraph that says, here's how for this document we're defining incompetency. Then my child can take over. So there's a couple different ways. Or if you've got your children, I appoint my 3 children as my power of attorney, and they all have to sign off together. I have clients who make them all work together, or I have clients that say whichever one can handle. Or I have clients that say, this one's a nurse, and I'm okay with the healthcare here, and this one's a banker, so I'm okay with the business here. Or this one's going to turn the machine off too soon, so I don't want that one. You'd be amazed what people will tell you in the lawyer's office. So it can be. And you know, these kinds of things that we're talking about here, that's really within your own family dynamics. I mean, you know people's propensities. You know how your children do or don't get along. What's hard, you know, some people have a hard time making decisions. You may have a child that's like that, and you may have an alpha child that knows exactly what's going to do and has from the day they were born. You know, so you've got to take all that into consideration. And just remember, all this is your best efforts. You know, things may not go exactly how you have planned, but you're doing it with the best information you have available at the time you're doing this.
A limited power of attorney.
Mm-hmm. Those are typically limited for a particular time or a particular purpose. A lot of times you may see a limited power of attorney because maybe you're selling your house and you're out of town, and so you're going to let your spouse take care of it, or a child or somebody. All right. They cease to be effective upon your death. So I have a lot of times people will come in and mama's passed away, and they say, no, I'll go take care of this because I have mama's power of attorney. And I have to say, no, you can't do that anymore because that's not effective. Because what a power of attorney does is it lets somebody stand in your shoes as if you could, while you were alive, and handle the things that you couldn't even do. So just like you couldn't go to the bank and sign a check if you were dead, they can't do it. Ceases to be effective. If you have a limited power of attorney for a 90-day window and you die before that 90-day window is up, ceases to be effective. Yep. Your property now belongs to whoever you've left it to in your will. Any other questions? All right. Make sure that you trust who you appoint, because I'm not going to get into your family dynamics on that one. So, but you're giving somebody the ability to do anything you could from a business perspective. So again, they can wipe your bank account out, they can sell your house, they can mortgage it. So you need to make sure that you trust implicitly whoever you appoint. If you don't have a power of attorney in place and you become incompetent, or if you have a situation where what we just talked about, a husband and wife have appointed each other and they're both in a car wreck and in a coma and we don't have an alternate, then you have to go the route of having a conservatorship done. And so what that means is you have to have a court declare a person incompetent and have somebody appointed to handle all this stuff for them. And that person has to go through court every year and make an accounting, all kinds of stuff like that. So it's a huge headache. And sometimes even if you have a power of attorney, you can't avoid doing that. Sometimes there are just things, you know, if you have somebody that's mentally incompetent and they're being taken advantage of and people are having to sign contracts and buy things and stuff like that, you have to go to conservatorship without strips that money. It's not an easy thing to do. You have to have a petition filed with the court. With that petition, the court is going to expect you to have a doctor that has examined them within a very close window of when that's filed. The court is going to appoint a guardian ad litem, typically an attorney, who's going to go and talk to the person that you're trying to have declared incompetent, talk to the doctors, get an idea of what all the assets are, and then the court's going to look at, and the guardian ad litem is going to look at who's asking to be the conservator and what their plan for managing the assets are and all that. So most people, 90 to 95% of the time, if you've got a power of attorney in place, your family is not going to have to go through that conservatorship stuff for you, okay? Because that can get really expensive too.
Why is it so expensive? You got to pay the medical exam and attorneys to set it all up and court costs and all that stuff.
Yeah.
I had a close friend who had schizophrenia.
Sure. Yeah, it can be a big deal. And like I said, it can be costly because, yeah, you've got court costs. You've got the lawyer who's filing a petition. You've got the lawyer lawyer who's appointed as a guardian ad litem. The person who's the conservator is entitled to be paid a fee for what they do. So, you know, there's all that can drain assets. Sure. With a conservatorship, one of the guardrails is you have to every year file a reconciliation with the court. Here's all the income court that has come in for this person. Here's all the expenditures that have been made. The court's supposed to look at that, and that's one of the guardrails. Now, do things get through that? Absolutely. Absolutely. You have people who can hide things and stuff like that. It is not a fail-safe provision. Neither is a power of attorney. You know, again, you're doing the best you can in that situation.
But if a person's targeted conservatorship, they have no assets, their assets have vanished, and that's one of the reasons you want to have a conservatorship to sort of protect them.
Right.
That can be done, right?
So if they don't have any assets,
Yeah.
yeah, but you can still have that conservatorship put in place, even if there's no assets to manage. Typically, you're going to have something to manage. You're going to have a Social Security disability payment or, you know, Social Security income. You're going to have to make sure that somebody's paying, if they're able to live independently, pay their utility bills for them or things like that.
They just don't end up out in the street.
Exactly. You don't want them to end up out in the street. Any other questions over power of attorneys? All right. Living wills. So this is a document where you indicate your preference about end-of-life decisions and not palliative care. I mentioned that, you know, some advanced directives get into, I've even seen them as specific as, you know, I'd like to have a bath every day and have my hair combed out. I have seen them very specific. From a lawyer's perspective, a living will, and I'm going to show you the language that we use here in the next couple of slides. It's very basic. It says, this is the language that, and this is literally, I cut and pasted this from ours into my slide here. If at any time I should have a terminal condition and my attending physician has determined there is no reasonable medical expectation of recovery and which as a result of a medical probability will result in my death, regardless of the use or discontinuance of medical treatment implemented for the purpose of sustaining life or the life process, I direct that medical care be withheld or withdrawn and that I be permitted to die naturally with only the administration of medications or the performance of any medical procedure deemed necessary to provide me with comfortable care or alleviate pain. Now, lawyer wrote that. It took about 500 words to say, if I'm about to die and but for a miracle I'm about to die, let me go. That's what that means. But dope me up and make sure I'm comfortable and out of pain, okay? That's what that paragraph means. Then that next section you see, in Tennessee, you have to make a specific selection with respect to artificially provided food, water, other nourishment, or fluids. So same triggering factors. You're in that terminal condition, but for a miracle, you're about to die. This is where you express what you want with respect to artificially provided items. So the first one says, I authorize you to withhold or withdraw those, meaning let me go, don't keep me on a feeding tube. The second one says, I do not authorize you to withhold or withdraw, keep me on the feeding tube. Some people have a hard time thinking about, you know, the reality of if you don't have a feeding tube, what that means as far as your passing. So, I have clients make different decisions based upon their personal preference. So you also, in that same document, you get to specify what you want to do with respect to organ donation. You choose between anything they want, the specific things I list, or no thank you. And that's what you make as your designation there. Yes.
What if you say, I want to donate my organs, but because of medical condition or something like that, no institution wants that?
Right.
Does it automatically drop down?
Yeah, this is all predicated upon there being a need or the ability. This is saying, if we're in a situation where somebody can use this, then I'm okay with them using it or not.
But do you have to say like parameters, or do you have to?
You can get that specific if you want to. if you want to. A lot of times you see it more specifically with respect to Vanderbilt and things like that, with respect to your body donation after death. And if any of you all are interested in that, Vanderbilt has a good program, although I have heard lately that they have so many that they're not taking anybody right now, but Neptune Society is another one. And typically the way that works, when you pass away, they come and get your body, they hold it at their facility. For Vanderbilt, it's for the medical school, and so they will keep the body at their facility until the medical students are able to use it, and then they cremate you and return your remains to your family afterwards. So that's typically how that works on a body donation.
That could be a long time.
Could be.
Yeah, see, we went through this.
Mhm.
Robin's mom and dad both gave us you started back in the hospital, so they gave the rights. It was your father.
Yeah, and we kept it for a year and a half. And then on the sidewalk, into the mom.
But it was longer than that for somebody because it was forever. I thought, then you have to go through the whole
The whole process.
thing again.
Yeah.
And I'm not sure, I don't know. It just-
Yeah. So that's, all of this stuff that we're talking about, what you want to do with your assets, who you want to be your power of attorney, what you want to do with your organs or your body or anything like that. Yes, it's critically important to have it in writing. But it's just as important to have those conversations with your family members so that they know, so there's no surprise, so that you can talk to them about just what you're talking about. This is what I would like to do with my body. Will you be able to handle it emotionally if a year and a half later, and so it's good to have those conversations. I'm not aware, all the people I've known that have gone through Vanderbilt, it has been cremated. And Vanderbilt's not the only one around here. I mean, some people just generally say they want to leave their body to science. Yeah. I've told Jeffrey I don't want to leave my body to science because I'm worried it'll wind up on the body farm at UT. And my mortal remains will be on UT Knoxville campus for the rest of and I just can't handle that, especially after Saturday. So, but these are all conversations that you guys need to have, and we're sitting here and we're laughing and giggling about this. And let's be realistic. This is a hard conversation to have. I can't tell you how many people come into my office and say, we have had this on our to-do list for forever. It's not fun talking about your mortality. It's not fun talking about what's going to happen after you die. Your kids don't, most of them, some of them may be real interested in what's going to happen with your assets, but most of them don't want to think about having to deal with their parents dying or who's going to get what, okay? So it's not fun. But keep in mind, I have yet to meet a client that's not going to have to deal with this or their family have to deal with it, And so you do all this to get yourself in as good a position, the power of attorneys and things like that while you're alive. You've got somebody that's trying to help you. So make it easier on them to do that. Same thing with your will. This is all about taking care of the people that you leave behind. And so have these honest conversations. Giggle about it a little bit. It kind of lets the tension out. It's something's going to happen to all of us. So, yes. That indicates your preference. Now, if push comes to shove in a court, I think this will be given more deferential weight. So, yes, and that can be used. I have some people that come in and say, I don't have it on my driver's license, but I want it here because I also want my family member to have the final say so. I want my family member to be the one to tell the doctor it's time to stop life support, as opposed to me being loaded up from a car wreck and they see on my driver's license I'm an organ donor. Any other questions on this? All right. Anything? Actually, I just covered that. This is all things that you need to do. Make a plan. Go see an attorney. You've got a good place to step off from on those forms. If you didn't get a form, let me know. I can get it to you. Talk to your family about your wishes. Most of them do.
Well, look, what you really want to do is you want to leave your will or direct, okay, when I die, you may need all the money, correct? So what I'm going to say is, Carolyn, when you die, you might fulfill my wishes.
Right.
And I could just say, would you do that?
Right.
And she may or may not do that.
Exactly.
Doesn't have to, but I can tell UT, well, yeah, you're in my will, not official.
Right. Right.
Because if I die and it's officially in the will, they
Then it
still
has,
say,
yeah,
I don't
yeah,
want to check.
yeah.
She's like, I don't have any other money.
Right.
They're like, sorry, and it goes to big orange, you know.
Exactly. So to your point, you may want to leave something to your church or to your university or ASPCA or, whatever charitable organization. But you may be more concerned about your spouse if your spouse survives you, having the means to support your spouse, or your minor children having the means to be raised. And that may be more important to you. And so you may just you can put it in your will if you want to say, if my spouse chooses to make a donation, this would be my preference. It needs to be very in the spouse's discretion. As you mentioned, if you put it in there and there's no discretionary, then UT's got it, so.
What he reinforced is that you and your spouse may be in a horrific car wreck. And she survives, but she's sued to the ground because you caused the car wreck and somebody was killed or whatever. So the assets you think are going to be there aren't there. Therefore, you need to shove everything to her when you're gone, and then she can decide what to do.
Right.
Or vice versa.
Right. Yeah. And a lot of times, with spouses, most everybody probably owns their property, their houses together with their spouse. That's automatically going to transfer to the survivor, regardless if you caused a car wreck and you're being sued. Bank accounts, things like that will have that automatic transfer out of the reach of those creditors. So that's one saving grace on that. But certainly individual assets or assets that are in your individual name, that may have some issues there.
What about if you both died in a common accident? Is there a preference to have it assumed in the documents that one dies first?
Typically, yeah, and the question was, if you both die in a common accident, what's the preference over who dies when? Typically, what we will do is we'll put in our documents, if we die such that the order of our deaths can't be determined, if we're on a plane crash, you don't know who's gone at what point, then to treat my spouse as having predeceased me. Your spouse's will is going to be a mirror image. It's going to say the same thing. And what that effectively does, it takes all of your jointly owned assets and splits them in half. So if you've got a $200,000 house, $100,000 of it's going to be yours, $100,000 is going to be hers, and then it's going to trickle down to whoever your alternates are on your will. And same thing, her creditors segregated half the estate and vice versa. I just got through with an estate, and I'm sorry, I won't keep you much longer. We're at 7:01. I just got through with an estate where the husband and wife were in a car wreck. He died at the scene of the accident. She died an hour and a half later. Guess what? We could establish order of death at that point. And so his will poured to hers, and then hers poured to the children. Now, theirs were mirror images, so it didn't make that big of a deal. But if they're not mirror images, then whoever dies last could make a difference over who gets what. All right, so are we going to do questions next week?
Okay, so this was the end of all the presentations that we had for this series, and we were sort of holding next week at the same time as a time for a workshop or additional questions. So my question to you now is, would you like that space next Wednesday? Martha Brooke can be here. We've got, funeral planning stuff, or are those questions you'd like to just kind of tackle one-on-one? Which basically means we're either going to meet next week or we're not.
I thought what you shared last week, what particularly Marshall shared, I have shared that with a bunch of people in the past week. Like, if you're going to go to a columbarium or whatever, call 1-800-MARSHALL down to the crematorium.
Okay.
And not have to go through funeral home and all that stuff.
Sure.
And boy, that's that's a significant saving that you could direct that money to a good cause
Yeah.
instead of funeral home
Okay.
expense, right?
But we don't need to come back and.
Yeah, we don't have to come back next week to talk about that, so. I'm not hearing any resounding, let's meet next week. Does anybody feel that way? You can tackle these things one-on-one for sure, meeting with Marshall or myself or Martha Brooke or Diane or Marilyn. And Lou Morrow,
If
yeah.
I have an accident going home tonight.
Lou Morrow can also help you. Does anybody else need a form from Martha Brooke from tonight? Or does everybody have one that needs one? Okay, thank you all for being a part of this 3-week series.